with respect to the fact that the 10 schedule proceedings are pending. Should he wait, not wait? Because the primary question will depend
Yes,
upon.
I bow down. My lords, I bow down. Your lordships have summed it up very well. May I just add to what your lordships are saying? In addition to what your lordships summarized, is my second limb of the argument that your lordships have already held in any number of judgments that an MLA during pendency of a disqualification petition is fully entitled to participate and vote. If that were so, then what is the hindrance to a floor test being conducted? And in all those matters, the issue arose the same. During pendency of disqualification petition, should the floor test take place or not? I'll show those paras. And your lordships answered by saying, why should the floor test not take place in the meantime? You can't, without the decision of the speaker, say that a person is disqualified. So
There's a little catch there.
You see,
There's a catch there.
the problem really is this, that the antecedent circumstances which give rise to the necessity of a floor test are based on an alleged defection.
right.
So, why is a floor test necessary? The need for a floor test arises because of the fact that a group of legislators may be disqualified as a result of their having formed a split from the party. This may or may
Not from, but
yeah,
yes.
yeah.
Within there's a rival
the legislature party. Now, if the validity or the legitimacy of the split is itself in question, then holding or directing the holding of a floor test before the disqualification issue is resolved would result in this, that are you not then putting a premium on the very circumstances which gave rise to the disqualification?
So my lords, your lordships have answered that, and I'll show those judgments where this very question arose, that can those MLAs against whom a disqualification petition is pending participate in a floor test?
There also you are right.
Look at the reverse.
Because the law is very well settled that the mere pendency of a disqualification petition does not preclude a member of parliament or the legislature in the state from exercising all rights and performing all functions of a legislator. Undoubtedly. But equally, we have to be cognizant of a situation where the reason why he or she can exercise all the functions as a legislator is because the speaker has been not permitted to decide the disqualification issue.
May I, with respect, say, my lords, as far as that
So
is
step
concerned,
one, the speaker is told to defer a decision on the disqualification issue. So the disqualification issue cannot be decided. Therefore, why can the legislator not be restrained from exercising all rights on the floor of the House? Because of the judicial edict that you shall not hear the disqualification until the 12th of July, step one. Step two, why is the trust vote required to be held? Up to the 21st June, there was never any requirement of a trust vote. What is the requirement of a trust vote? The requirement of a trust vote arises because these 7 independent MLAs, then the 34, they all start clamoring and they say, well, there is disquiet within. We don't owe allegiance, and our chief minister has lost the confidence of the party. Now, the point of the matter is this, that if that is the reason for the unsettling of the government in the House, then the antecedent basis of that is itself the allegation of disqualification. So if you allow a government to be toppled then in circumstances...
May I, with respect, say, firstly, and
Yes.
I said I've just begun.
This is not
timelines.
Just flagging it. Just flagging it.
Yeah, we are just flagging it.
No, I am very grateful. Yes.
Right? These are the concerns.
Yes.
This is not a case where, say, there is a 3-party or 4-party coalition in a state. 2 parties say we are pulling the rug. They're entitled to, there's no disqualification. You have 4 parties which have come together in an agadi, and those 2 parties say we are pulling the rug and we want to get out of this government. It doesn't have the mandate of why we came together. Governor can simply say, the 2 of your constituents have, pulled out. Now, please show me that you established you have the allegiance of the House. Because there is no, The problem arises in cases like this, where the reason for the trust vote is so intrinsically related to the alleged disqualification itself. You're right. My judgment in Shivraj says that, well, these are two independent issues. But there is
No,
there
let
is
me,
also an intrinsic
so
connection.
my lords, let me,
Call one another thing. In addition to this, what are their submissions? There is no difficulty that both are independent. Correct? There is no difficulty that both can go together simultaneously. But their submission is correct that if those persons who are to be against whom the disqualification proceedings are pending are permitted to cast their votes on the protest in the no confidence motion. If ultimately after some time, correct, the speaker takes a decision and they are disqualified from day one, from the date of their conduct, correct, then what will happen to that? So their case is that it is better, correct, that the disqualification proceedings are initiated first. That is what their submission. You have to answer that also.
yes, my lords, I will.
That is the crux of that main submissions.
May I? Let's firstly,
You can argue on this was only warm up.
yes,
Let's start with Bomai. Because
yes,
Bomai
my lords, I thought let me start with that and I'll come. I'm conscious what my lord has said. I'm very grateful. I'll address those questions.
anything more than 5 in that sense is gospel for us, because we are bound by.
Not only that, my lords, of course, your lordships are
ultimate
right
test.
there, but even I want to show 2 paras, even as far as Bumai is concerned, on how Shivraj deals with it. It's important for your lordships to see that.
Fair enough. So we'll see Bomai and then
Yes, first please see Bumai and then see.
Overarching principle.
Yes, yes. Judgment. Judgment. Volume 2. Kindly have para 119.
where is it? Convenience compilation?
Volume 2, my lords.
All right.
Judgment compilation, volume 2, PDF page 368. PDF page, as well.
PDF page
PDF page 368.
358.
368.
This is great dismissal.
No need.
119.
Savant.
Who gets the read?
My lords, may I?
Yes.
Absolutely. But in this connection, it is necessary to stress that in all cases where the support of the ministry is claimed to have been withdrawn by some legislators, the proper course for testing the strength of the ministry is holding the test on the floor of the House. That alone is the constitutionally ordained forum for seeking openly and objectively the claims and counterclaims in that behalf. The assessment of the strength of the ministry is not a matter of private opinion of any individual, be he the governor or the president. It is capable of being demonstrated and ascertained publicly in the House. Hence, when such demonstration is possible, it is not open to bypass it and instead depend on the subjective satisfaction of the governor or the president. Such private assessment is an anathema to the democratic principle, apart from being open to serious objections or personal malafides. It is possible that on some rare occasions the floor test may be impossible, although it is difficult to envisage such a situation. Even assuming that there arises one, it should be obligatory on the governor in such circumstances to state in writing the reasons for not holding the floor test. The High Court was therefore wrong in holding that the floor test was neither compulsory nor obligatory, or that it was not a prerequisite to sending the report to the president recommending action under 356(1). Since we have already referred to the recommendations of the Sarkaria Commission in this connection, it is not necessary to repeat them here. Now kindly have para 121, same page. We may, on this subject, refer to the unanimous report of the 5-member Committee of Governors, which recommended as follows. The test of confidence in the ministry should normally be left to a vote in the Assembly. Where the governor is satisfied by whatever process or means that the ministry no longer enjoys majority support, he should ask the Chief Minister to face the Assembly and prove his majority within the shortest possible time. If the Chief Minister shirks this primary responsibility and fails to comply, the governor would be in duty bound to initiate steps to form an alternative ministry. A Chief Minister's refusal to test his strength on the floor of the Assembly can well be interpreted as prima facie proof of his no longer enjoying the confidence of the legislature. If then an alternative ministry can be formed, which in the governor's view is able to command the majority in the Assembly, he must dismiss the ministry in power and install the alternative ministry in office. On the other hand, if no such ministry is possible, the governor will be left with no alternative but to make a report to the president under Article 356. Now kindly have para 391 on PDF page. PDF page 517. 391. 395.
Yes.
My lords have para 390.
Yes.
We must also say that the observations under point 7 is equally misplaced. It is true that action under Article 356 is taken on the basis of satisfaction of the Union Council of Ministers, but on that score, it cannot be said that legal malafides of the governor is irrelevant. When the article speaks of the satisfaction being formed on the basis of the governor's report, the legal malafides, if any, of the governor cannot be said to be irrelevant. The governor's report may not be conclusive, but its relevance is undeniable. Action under 356 can be based only and exclusively upon such report. Governor is a very high constitutional functionary. He is supposed to act fairly and honestly consistent with his oath. He is actually reporting against his own government. It is for this reason that the Article 356 places such implicit faith in his report. If, however, in a given case, his report is vitiated by legal malafides, it is bound to vitiate the president's action as well. Regarding the other points made in the judgment of the High Court, we must say that the High Court went wrong in law in approving and upholding the governor's report in the action of the president under Article 356. The governor's report is vitiated by more than one assumption totally unsustainable in law. Constitution does not create an obligation that the political party forming the ministry should necessarily have a majority in the legislature. Minority governments are not unknown. What is necessary is that the government should enjoy the confidence of the House. This aspect does not appear to have been kept in mind by the governor. Secondly, and more importantly, whether the Council of Ministers has lost the confidence of the House is not a matter to be determined by the governor or, for that matter, anywhere else except the floor of the House. The principle of democracy underlying our Constitution necessarily means that any such question should be decided on the floor of the House. The House is the place where democracy is in action. It is not for the governor to determine the said question on his own or on his own verification. This is not a matter within his subjective satisfaction. It is an objective fact capable of being established on the floor of the House. It is gratifying to note that Shri Raman, the former President of India, has affirmed this view in his Rajaji Memorial Lecture. And now kindly have para 390.